The basic premise of 1070 is that it allows police officers to ask individuals about their immigration status if they suspect that the person is not legally in the country. And what gives them an opportunity to do so is if they come into a contact with the individual in the course of their everyday policing powers, and the person is not unable to produce an identification from the state of Arizona or another state that has similar requirements as to who gets identifications. Well, the primary question as to the constitutionality of the law is grounded on the fact that immigration law is normally enforced through the federal process, and physical presence in the United States has been deemed to be a civil violation by the federal government. And they treat it as such, and they punish individuals for that civil violation with deportation. The state is inferencing that by making physical presence a criminal violation of state statute, it can go ahead and prosecute individuals for said violation. So there's the question as to whether or not the federal government will allow the states to take something that they punish as civil to be allowed by the states to be punished as criminal. Well, the United States, in making its choices on prosecution and what different levels of criminals we have, created a law that says that a person who is in the process of coming in is violating the law. But once a person is in the United States, that crime is not, there's no crime of being here. There's a crime that if you catch them coming in, you can prosecute them there. But once they're in the United States, it's not. And it's really a practical reason. It is very difficult by the federal government to identify individuals who are violating any physical barriers when they're already in a place with everyone else. And two, when you make something into a criminal action, it opens up a large number of rights and obligations from the part of the United States, including the appointment of counsel. And you can imagine the cost of providing counsel to 12 million individuals living in the United States. But it's something the United States decided a very long time ago at the onset of our immigration laws, that we were not going to punish individuals criminally for being in the United States. Well, I mean, in public schools there is less freedom for teachers and for students as to what is provided to them in the classroom. And so it's slightly different from what you would see in the university. And however, what the biggest danger of the statute is that it gives the superintendent too much power to decide at his whim whether or not he feels the particular program is violating the statute or not. And that kind of overseeing power is always seen with some fear by the public, because you want as much transparency as you can in the process of educating children. Well, the citizenship issue is something that has come into vogue again. It was in vogue in 1996. But it's something that is extremely old. It was decided by a Supreme Court decision last century that the 14th Amendment only excludes individuals who are born to foreign diplomats. And ironically, Indians, because at that time they were not considered to be citizens of the United States because they were parts of tribes.